Welcome to this presentation regarding the second half of Chapter 5. I'm going to show you the initial slides in case you missed a blank. Just pause it if you need to spend a little bit more time on the slide. Okay, let's begin talking here on slide 10. We've discussed the concept of jurisdiction, but we haven't discussed the concept of general versus limited jurisdiction. So let's spend a little bit of time on that idea. We see here the word general and the word limited. A court of general jurisdiction is what most courts are in our system. For example, if I file a lawsuit in a district court, say in Collin County, that court is going to hear lots of different topics. It will hear car accident cases, it will hear divorces, it will hear criminal matters, it will hear contract disputes. So pretty much anything that arises in Collin County that is of a certain amount of money, that a certain amount of money is at issue, is going to go into that court. So it's a court of general jurisdiction, meaning that as a general rule, any of the lawsuits in that area could be filed in that particular court. There are also courts of limited jurisdiction. We don't have as many of those in Texas as other states might have. But let me give you some examples. There are some systems that have a court that only has criminal jurisdiction. That's the only type of case it handles. There are other systems that have probate courts, that's all that they handle. There are some systems that have courts that are just family law courts. So those would be examples of courts of limited jurisdiction. In Texas, we do have some courts of limited jurisdiction. We have small claims courts, or JP courts. They handle court cases that involve very small amounts of money. So instead, the thing that these courts have in common as opposed to the court of general jurisdiction is where the court of jurisdiction handles all cases except for a few little carved out areas. Well, the courts of limited jurisdiction are those carved out areas. They're not going to handle most disputes that arise in a particular jurisdiction. Even though we don't have a lot of courts of limited jurisdiction in the Texas system, we do have a fair number in the federal system. For example, if you are filing a bankruptcy, you are going to file that in a federal bankruptcy court. And guess what? That court handles only bankruptcies. There are also specialized tax courts, and there are specialized maritime courts. Courts having to do with disputes involving things that are happening at sea, for example. So, if let's say I am representing a client who's filing for bankruptcy, and I filed the dispute in a court of general jurisdiction, well, that court will say, quite reasonably, we don't do bankruptcies. You have to go to the bankruptcy court, and that's where you have to file that document. And so the court of general jurisdiction isn't going to have authority to handle those cases because it's one of those carved out areas. Similarly, if I file a contract dispute involving two entities that aren't in bankruptcy, and I file that in a bankruptcy court, the bankruptcy court will say, no, we just handle these carved out territories. We don't handle the garden variety disputes. You have to go to a court of general jurisdiction for that. So that's how the distinction works. You have to make sure not only are you choosing which state, which is personal jurisdiction, and you're also choosing, do I file in state court or do I file in federal court? So we've already answered the question, which state and federal, or state. But then you also have to consider, is this one of those weird, I'll say weird in a derogatory way, but one of those unusual topics that I have to file in a court of limited jurisdiction? Because if I make the wrong choice, then I am, the case is, I'm going to be embarrassed, there's going to be expense, and it's just not a good thing to file in the wrong court. So then finally, is there a court of limited jurisdiction that handles these types of issues? Okay, and I won't write out the word jurisdiction, but you get the idea. That's I guess the third question we have to ask ourselves. Which state am I going to file it in? That's all about personal jurisdiction. We look at where the defendant has personal ties to that particular state. If the defendant does, then under the Washington versus International Shoe case, it can be filed in that case, in that particular state. And there might be several states that a person has that connection. Certainly the state where he or she is a resident, and also where he or she routinely does business. Then we have the issue of, well, okay, we've decided what state we're going to file in, but each state has courts that are both in their own state system and the federal system. So to make that decision, we have to look at subject matter jurisdiction. The default rule, of course, is that we file in state court. We need a special reason to be able to file in federal court. And we talked about those reasons in class. We talked about the fact that there has to be, if there's a U.S. constitutional issue, we can file in federal court. If there's a U.S. treaty involved, we can file in federal court. If the United States government is either a plaintiff or a defendant in the case, we can file in federal court. If there's a federal question, meaning a federal statute at issue, we can file in federal court. If sorry about that, I got a call there a minute ago. Okay, so we're going back. So we've talked about personal jurisdiction answers the question, which state am I going to file my lawsuit in? Subject matter jurisdiction answers the question, am I filing in the state court in that particular state or the federal court in that state? And then the last issue is, well, is there a specialized court that handles the type of dispute that I am involved with? If so, I'm going to file it in that court of limited jurisdiction. If there isn't a specialized court, then I'll file in a court of general jurisdiction. And both the state system and the federal system have courts of limited jurisdiction, so it's an issue to think about. The other way to look at jurisdiction is whether we're filing in a court of original jurisdiction or one of appellate jurisdiction. This one's really easy. Nobody makes a mistake in this area, but there are two important concepts to be familiar with. So a court of original jurisdiction is where you originate a lawsuit, where you begin a lawsuit. So this is the first place. This is oftentimes called a trial court, right? This is where you go first. A court of appellate jurisdiction is, of course, an appellate court. This is where you go after you've lost at trial and you want to get that verdict overturned. So if I file my original lawsuit in the Texas Court of Appeals, well, they'll say, no, we don't hear those cases except after the trial court has decided it. So you filed in the wrong place. Okay, so we've discussed the different types of jurisdiction. Now we're going to talk about venue. Venue is not a type of jurisdiction. I can practically guarantee you that there is going to be a question on the midterm about venue being a type of jurisdiction. And it's not. It is a related concept, but it is not the same thing as jurisdiction. So if you see a question that says venue is a type of jurisdiction, and it's a true-false question, you know, boy, that's false. I don't even have to read any farther. And so it's not a type of jurisdiction. It's a related concept. You remember how we talked about how jurisdiction is an on-off switch? You either have jurisdiction or you don't. You don't have a lot of jurisdiction or just a little bit of jurisdiction. Just like when you're flipping a switch in your house, the light's all the way on or it's all the way off. If you have a dimmer switch, that's a different situation. Dimmer switch is more how venue works. Venue considers lots of different factors in deciding whether this is the best place to file a lawsuit or not. So it considers things like, what's the most appropriate place? Again, in jurisdiction, you might have several different places you can file the lawsuit. And the plaintiff gets to pick between all those places where the lights are on. In venue, because things are compared, it may be that there's the different levels of appropriateness. Usually venue is going to exist where the defendants reside or where the relevant event happened. Let me give you an example. I'm going to clear my screen here. Well, let's see, I don't remember how to clear. Oh, here we go. Clear page. Okay. Sorry about that. Okay, so now we're going to talk about venue. So let's imagine that we're going to go back to doing a little T-chart. Is even though venue isn't a type of jurisdiction, T-charts do kind of help us make a little sense of it. So here we go. We have our T-chart. We have our plaintiffs over here. We have our defendants over here. Bob has been in a car accident with Mary, and Bob wants to sue Mary. Bob also wants to sue Larry. Mary was the driver of the car that hit his car. Larry is the owner of the car, and Bob thinks that Larry perhaps did not maintain the car, maybe the brakes or what was the problem. So he wants to sue two people. He's decided he's going to sue in Texas State Court, a general jurisdiction, because there's no specialized court that handles car accident cases. So we know it's Texas and we know it's state versus federal. Bob lives in Collin County. Mary lives in Tarrant County. And Larry, we'll say, lives in Dallas County. The car accident about which Bob is suing, we'll just say that the situs is in El Paso County. So even though Mary and Bob are from the Dallas-Fort Worth area, they coincidentally, both of them were vacationing in El Paso. So Bob can sue Larry and Mary in Tarrant County because one of the defendants is there, or Bob can sue Larry and Mary in Dallas County, which is where one of the other defendants lives, or Bob can sue in El Paso County. Bob, however, cannot sue in Collin County because the location where the plaintiff is isn't relevant to venue. Because after all, when a lawsuit is filed, Mary and Larry are the people who are inconvenienced, right? Bob is the one choosing to file the lawsuit, so we're not really that concerned about his convenience. So we look at where the defendants are located. Now it could be, let's add a third defendant to this case. Let's say that Harry was the repairman who worked on the brakes, and maybe he did a bad job. Well, Harry lives in, we'll say, Travis County. Well, Travis County is not very convenient, to Tarrant or Dallas County. So to be sued in Travis County is a pretty big inconvenience for Larry and Mary. But guess what? Bob doesn't have to worry about that because Bob, as long as one of the defendants, even if there's 100 defendants, as long as one of the defendants is from that particular county, even if it's a far distance from the other counties, Bob can choose it. Then most likely Bob is going to stick with Tarrant or Dallas County because he's from Collin County. That would be convenient for him as well. But there might be some strategic reason that he thinks El Paso County might be better. Some people think this isn't really in the valley, but kind of in the valley, I guess you could say. People think of the counties around Brownsville and Eagle Pass and Laredo and places like that typically are more pro-plaintiff. So sometimes even if none of the events in the lawsuit necessarily happened in the valley, if there is a basis for venue to exist, say one of the defendants was from Brownsville or something along those lines, then the plaintiff might choose to file there simply because he thinks that the juries in that jurisdiction might be more sympathetic to his plaintiff's case. So venue is where the most appropriate for a trial is. But let me offer a different example. Let me go ahead and clean this off, and we'll present another scenario. Okay, Bob is still, wait a second. Bob is still the plaintiff, and Mary is still the defendant. So we have Bob, oh, wait a second, sorry. We have Bob and Mary. And we also have Larry. So Mary was the driver of the car, Larry is the owner of the car. Now both Mary and Larry have lots of contacts within Texas. They routinely travel to Texas on business, and so personal jurisdiction exists for both Mary and Larry in Texas. Bob is a Texan. He's actually from Collin County. But Mary is from an Oklahoma county, and so is Larry. So because the counties in which they live are not within the state of Texas, their counties are irrelevant because Bob has decided to file his lawsuit in a Texas state court of general jurisdiction. And Oklahoma counties obviously aren't within those borders of the state of Texas. So there is no county to consider for Mary, and there is no county to consider for Larry. And let's say the accident actually happened, we'll say the situs was in Oklahoma. Bob was visiting in Oklahoma, Mary and Larry were in their home turf, and so the actual place where the accident happened is also not in Texas. So there is no county where the parties reside, or where the defendants reside. And there is no county in Texas where the relevant events occurred. In that situation, and only in that situation, Bob can pick any Texas county. He's likely to pick Collin County, but he could pick El Paso County or whatever county Brownsville is in if he wanted to, because any county goes if there isn't a county where any of the defendants are from or where the accident itself happened. So that's a little weird exception to the policy. And you can see how venue is a more flexible concept. Jurisdiction is on-off switch. Venue is more like that dimmer switch. Okay, last thing to think about, and this is perhaps the best clarification, is why venue is not a type of jurisdiction. Venue is a choice between places that already have jurisdiction. So you're choosing between, again, we've decided that Texas has jurisdiction over the defendants, and we've decided that we're going to file in state court. So so as soon as one county in Texas has jurisdiction, as a matter of law, every single county in Texas has jurisdiction. So it isn't that, oh, well, Collin County has jurisdiction, but Rockwall County doesn't. No, if one county in Texas has jurisdiction, every single county also has jurisdiction. But that doesn't mean venue is appropriate. So venue is a comparison between places that already have jurisdiction. Now, if as it happens, in this last example, where no county is ideal for jurisdiction, well, in that situation, any county that has jurisdiction, which would be any county, can be the place where the lawsuit is filed. So venue is a choice between places that we've already figured out have jurisdiction. So as a result, you always do the jurisdictional analysis first. You always look at personal jurisdiction, then you look at subject matter jurisdiction, and then once you've figured out that you're filing in a particular state, whatever that state might be, and whether you're filing in the federal system or the state system, then you're trying to decide which county or federal district is the one that is best for jurisdiction. Okay. Every now and again you may hear, this especially happens in criminal cases, that there may be a move to transfer jurisdiction. Let's imagine a case that's gotten a lot of publicity. Maybe it's a sensational murder trial and it's been in the press a lot. Well, sometimes criminal defendants' attorneys will say, I'm not sure that my client can get a fair trial because the jury pool will have been tainted. Everybody who would be called up for jury duty has heard about this case in the press, and maybe there has been some inaccurate statements made in the press that might prejudice the jury even before they've heard the evidence against my client. Well, the judge under those circumstances can hear and say, well, ordinarily, yes, this jurisdiction has venue because perhaps this is where the crime happened, for example. But given the fact that there might be this tainting of the jury pool, we can transfer venue to another place. And that sometimes happens. Not commonly, but occasionally it will happen. Okay, so we've talked about jurisdiction and now we've talked about venue. Let's also talk briefly about judicial procedures. We talked a little bit about the difference between substantive law and procedural law in a previous lecture. Substantive law is about the rights and duties that people have. It's about the content of the law. It's the substance of the law. Procedures, though, are pretty much separated from the content of the law. For example, if I'm filing a lawsuit in a Texas district court, and let's say it's a civil dispute, I'm going to have to follow the same procedures whether I am filing a contract dispute or I'm filing a car accident case. Very different legal substantive law, but the deadlines that I have, the rules about what my documents have to look like would be the same, and so the procedures would be the same. So the procedures don't talk about what my rights and duties are. They talk about things like deadlines, what my documents need to look like, what the names of documents are, things like that. An example of a set of judicial procedures is the Federal Rules of Civil Procedure. Those rules apply to any federal case that is filed that is a civil matter. There's also, of course, the Federal Rules of Criminal Procedure. And in Texas, we have similar rules. We have the Texas Rules of Civil Procedure, and guess what? The Texas Rules of Criminal Procedure. So those rules would apply no matter what your criminal dispute is, whether it's a capital murder case or a robbery or an arson case. It doesn't focus upon what are the particular elements of that particular claim, but it's focused on what are the rules. How do we go from step A to step B? Let's talk about state court systems. As we said before, every state has its own court system, and the D.C. has its own court system. So we have 51, and of course that's not even counting Puerto Rico and the other parts of the United States that aren't associated with the state. Each state has its own little twist to its court system, so I'm going to talk generally about the court systems in the states, making some generalizations. I'll talk specifically about Texas. Usually in most state court systems, the judges are elected for a specific term. There can be a variety of ways that this is handled. In some states, these are nonpartisan elections. In some states, they are the judge is appointed, and it's an up or down vote about whether that judge continues in position each time that there's another election. In Texas, we have partisan elections, so a judge will declare himself or herself as typically a Republican or a Democrat, although of course it could be a third party, and that judge is reelected every 4 years if, of course, the public wants to reelect that person. Let's talk about the trial courts. In a trial court, you have a trial judge who presides over the case. He decides, makes evidentiary ruling, instructs the jury, establishes what the rules kind of are going to be in the case. Most trials in Texas are jury trials, but it is possible to have a non-jury trial. Sometimes if it's a criminal case, sometimes is a constitutional right to a jury trial in such cases, but sometimes the criminal defendant may elect to have a non-jury trial. Maybe he feels that the judge would give him or her a better shake than a jury trial. Most civil cases are jury trials, but there are times where the particular rules about that type of claim require a non-jury trial. Let me give you an example. A dispute about certain community property aspects is going to be a non-jury trial. It's going to be decided by the judge. Some issues relating to the best interests of the child will be established by a judge, not by a jury, although juries do establish certain aspects of it. So you have to go and look at the law to see whether that's a jury topic or a non-jury topic. When you are the plaintiff and you file your complaint or petition, whichever court system you're in determines the name of the document, you oftentimes elect at that time or very shortly after whether you want a jury trial or a non-jury trial. If the plaintiff elects to have a non-jury trial, the defendant can elect, hey, well, the plaintiff didn't want a jury trial, but I do. And then the defendant can elect to have a jury trial. Of course, if both parties want what's called a bench trial, and so non-jury trial is called a bench trial, meaning the judge from the bench, it's not really a bench anymore, it's a seat, but from his seat will decide the case. But if both parties want that, then that's how it will proceed. At trial, the attorneys will present evidence, and this will include calling witnesses who under oath present testimony, and also through witnesses, documents and exhibits can be brought into evidence. The attorney for the other side can cross-examine any witnesses that the first attorney has called, asking them the witnesses questions about their testimony. And he can make challenges. For example, he can make objections and say, objection, Your Honor, give a basis, and the judge can rule whether the witness can answer that question or not. The jury, if in a jury trial, the jury decides the facts of the case. Of course, if it's a non-jury trial, if it's a bench trial, the judge would have that role. However, the judge decides the law in the case. So there are times where the judge will make a decision, and there will be times when the jury will make a decision. Now let's imagine that there is an issue about a particular statute, and maybe the statute was not worded well, and so it's unclear what the legislature meant on a particular issue, whether let's say it's a criminal case, what the elements of a particular crime is. And so the judge has to provide clarity. The judge looks at the statute, the judge looks at the case law, and determines what he or she thinks is the likely meaning of a particular term or a particular requirement. Then the judge will tell the jury, this is how you should assume that the law is in this area. So the judge tells the jury what the law is. Then the jury takes that knowledge from the judge and then he considers the evidence that it has heard and decides whether the facts that it has heard, how that connects with the law that it has been given. And if it finds that, yes, the facts do support the law that the judge has given the jury, then the jury will find in favor of, if it's a criminal case, the prosecutor, if it's a civil case, the plaintiff. On the other hand, if the jury finds that the facts don't adequately support the law that the judge has given the jury, then the jury will side for the criminal defendant if it's a criminal case, or the civil defendant if it's a civil case. After the jury renders its decision, then the judge issues a judgment. You can see, it makes sense that the judge would issue a judgment because it starts with the word judge in it. We already talked about the differences between courts of general and limited jurisdiction. And here are some examples. In states you might have family court, probate court, small claims court. And in the federal system you could have a bankruptcy court or a tax court. Otherwise, if it's not in a court of limit, these are all limited jurisdiction here. A court of general jurisdiction usually begins with the word district, meaning all the cases in that particular district can be filed in the court of general jurisdiction unless there's one of those carve-out topics where there's limited jurisdiction. Okay, so we're still talking about the state system here. And we have the word appellate. Appellate is where you file your appeals. This is a point of confusion sometimes because in English when we have a word that ends A-N-T versus A-T-E, they sound very similar. So let me say appellate, appellant, appellant, appellate. Sound very similar when we have a word that ends this way or word ends this way. It's important to remember that the appellate, I'm going to emphasize the A, although we wouldn't say it that way really. The appellate court is like this. The baby is eating, right? So that's where the word ate. We have appellant court. That's when we have the little insect here. An appellate court is the court who hears the case. An appellant is the person who files the appeal, the filer of the appeal. He's a partisan. He's on a particular side. He's on his own side. He is not objective, neutral. He is trying to win. And of course, the person that he's trying to win, or to win over, is the appellee. That's the person who is being appealed against. So you can think about the appellant as being like the plaintiff of the appeal. He's unhappy, I mean the pi sign here, plaintiff of the appeal. He's unhappy with what happened in the trial court and he wants to get it overturned. The appellee is like the defendant in the trial case. So he's the defendant of the appeal. He likes what happened in the trial court. He won there, so he wants that to be maintained. So it's important not to say the appellant court, because that would suggest that the court sides automatically with this guy. Of course, that wouldn't be a very good justice system if you had the court automatically being on the side of one of the parties. So when we talk about the appellate court, we mean it this way with the ATE. Of course, we have an automatic right of appeal, one right of appeal automatically for whomever lost a trial. And so that party, in this case the appellant, can file an appeal even if it's silly. He doesn't have to ask any permission. Now he's going to have, there's some costs associated with it. He has to pay those costs, but if he wants to proceed, he certainly can. The basis of the appeal is going to be that the appellant is saying that there was some type of reversible error. And when we say reversible error, we mean there was an error of law that is so significant that it affects the outcome of the case. Now, the reality is in a trial, the judge is going to make hundreds, probably thousands of decisions. No judge, no matter how brilliant he or she is going to get every single decision right. That would be like, batting 1,000 when you're coming up to bat. A good judge is probably going to get 90, maybe even 90%, 95% of the decisions right. But he's not going to score 100. And so there's going to be errors. That's a given. That's a certainty. Everybody knows that. But, of course, we don't have a system in which the judge made one insignificant error. That's not going to result in the case being overturned, because if we had that standard, every single trial could be overturned, because every single time the judge is going to make at least one mistake. And see how crazy that system would be. You'd have every single case being tried multiple times, with multiple jurors being inconvenienced, multiple witnesses being inconvenienced, and we'd need, hundreds and thousands more judges just to handle the system. And you'd never have finality, and the cost of litigation would be so huge. So we don't overturn a case because there's been an error. We know there's going to be errors. We overturn it only when the error was so significant that it likely caused the wrong side to win. If that error hadn't happened, it's likely the jury would have sided with the other guys. So that's the standard. About 10% of cases are appealed, and about 10% of the appeals are overturned. So that means there's only about a 1% chance that a jury or a jury verdict is going to get overturned. Seems like it's more than that, because when we hear in the news about appeals, it seems like we hear about the appeals that are successful, because the ones that are unsuccessful are kind of boring. Oh, okay, well, what the trial court did is upheld. That doesn't sound very exciting. But the reality is that what happens in the trial court is almost always the end of the story for a particular case. And that makes sense, because after all, trials are expensive things. They're expensive for the litigants, but also expensive for you and I as taxpayers. We don't want to have to do that multiple times unless there's a really good reason why we need to. And that related to that is that there's great deference to the court's findings of fact. The appellate judges, and there's typically going to be 3 in a panel, they didn't hear the live testimony. They didn't see the demeanor of the witnesses. They didn't dive into the facts the same way that the trial judge can dive into it, because he's there, she's there around the front lines. And so the appellate court realizes that they're really not in a position to develop really a sense of, well, who's right and who's wrong. They're really focusing on what the law, did the judge misstate the law? But when the judge says that this is what happened, these are the findings of fact, there's great deference, unless there's just no support for it. If it's something ridiculous, there's no evidence that says what the judge says it said. That would be a time in which an appellate court might overturn. But it's very rare for an appellate court to overturn a trial court's finding of fact. Now, it's finding of law, yes, that happens. Okay, well, in Texas, as well as in most state systems, there are 2 levels of appeal. We have the trial court down here. We have the first level of appeal here, which is the intermediate level, and then we have the highest courts, which are typically called Supreme Courts. This is an automatic right of appeal. No matter how weak your case is, if you pay the right fees and do the right paperwork, you get this. The next level in the Texas system and most other states is not an automatic right. You can try, you can appeal and see if that court will hear, but the reality is the Supreme Court in states have so many requests to hear the cases, and they don't have sufficient time to go through all those cases. And so most of the time, the highest court in the state will say, no, we don't have time for your case. It's not sufficiently important. You have the right to ask, but you don't have the right to be heard. The highest state court, this third level, is going to be the final arbiter, the final decider of questions of state law. We usually think about the U.S. Supreme Court as being the final arbiter of what the law is in the United States. And it's true, it is, for federal law and for U.S. constitutional law. But the Texas Supreme Court would be the final arbiter of decisions about Texas civil law, unless, of course, there's some constitutional issue. So let's say the Texas Supreme Court said, this is what Texas contract law is. And let's say that someone appealed just to the U.S. Supreme Court. Well, the U.S. Supreme Court wouldn't question the judgment of the Texas Supreme Court about contract law in Texas, unless there was some kind of constitutional issue, which would be unlikely. They would accept whatever Texas said is what the law is. They would not rethink or reconsider that law. They would accept it as a given. Okay, so this is a schema. This is from the textbook. It kind of shows you the system that we have here, and you can see it kind of breaks it down. Here is how the Texas system works. We actually have, as far as I know, there's only one other state, Oklahoma, that has this system. We have the district courts down here. They are the courts of general jurisdiction. That's where most of the action in the trial court is going to be. And then you appeal to the Court of Appeals. We have the same Court of Appeals whether they're criminal cases or civil cases. So let's imagine that I file a case in Dallas County District Court. It could be a civil case or a criminal case. Then let's say it's a civil case. I lose. Well, I'm going to file in the 5th Court of Appeals, which is the Court of Appeals that handles Dallas County. Even if it were a criminal case, and say I was a criminal defendant and I had lost at trial, then I would be able to file in the 5th Court of Appeals. So this level handles criminal and civil. This level handles criminal and civil. We bifurcate, though, when we get to the highest court in the land. And if it's a civil matter, it's going to be the Texas Supreme Court. If it's a criminal matter, it's going to be Texas Court of Criminal Appeals. Sometimes when people see these names, they think, well, this sounds more important than this court. After all, it has the word Supreme in it. But that's not really true. This is the Supreme Court for criminal matters, and this is the Supreme Court for criminal matters, and this is the Supreme Court for civil matters. Each one of the courts has 9 justices, including a chief justice. Now, we just have more civil litigation than criminal litigation, so this is, in some sense, the more important court. And there are a few functions the Texas Supreme Court does that the Texas Court of Criminal Appeals doesn't do. And so in some sense, this is the most Supreme Court. But if it's a criminal matter, the Texas Supreme Court's not even going to hear it. The only path is over here. So just think about this being the Supreme Court for criminal matters, and this is the Supreme Court for civil matters. We also have courts below the district court level because these involve fairly significant dollar amounts. So county level courts handle cases that are a little bit smaller. Municipal courts handle cases a little bit smaller than that. And we have JP, or justice courts, the small claims courts that handle very small dollar amount cases. Okay, so we've talked about the Texas state system as well as generally about state systems. Now let's talk about the federal system. Federal judges are not elected. They are appointed by the president, and then they are confirmed by the Senate. And the appointment is for life. They are never going to need to be reappointed. They can work until they, of course, die or until they retire, and they can also be impeached if they do some type of impropriety. That's not common. It certainly has happened. So most of the time when federal judges become federal judges, they have a pretty secure job situation for the rest of their lives. There's not a lot of review that happens. And the reason for that is that in the federal system, we want judges who are independent. If they had to worry about getting reelected, they might not make the decisions that might be unpopular for the people in that community, but are the right decisions in terms of the law. That's a different philosophy in the state system, whereas we want judges to be accountable because we require that they be elected. Those are just 2 different models. And again, that's a difference in our federal system between the state system and the federal system. Like the state system, we do have that 3-tier model where we have the trial courts, we have the courts of appeal, and then we have the U.S. Supreme Court. A U.S. district court is just like a Texas district court. It is a court of general jurisdiction. That is where the trial courts are. They have original jurisdiction in matters of federal law. You know, those 5 bases to go into federal court. If one of those are present, then you can file in federal court in that court of general jurisdiction. Every state has at least 1 district court. Now, when I say a district court, I don't mean that there is a single courthouse. There may be, in certain states, just a single courthouse. We have 4 district courts, but each one of these districts has multiple courthouses. So when we say that there are 4 district courts, we don't mean that there are 4 district courthouses in Texas in the federal system. No, there's many more than that. But they are divided into 4 territories. We have the Southern District, which includes the Houston area, for example. We have the Northern District, which includes the Dallas County and Tarrant County. We have the Western District, which includes El Paso and things west. We have the Eastern District, which includes Plano, or not just Plano, but Collin County, and Texarkana and places to the extreme east of the state. You do need to know these facts. You will see them on a test. Collin County is in the Eastern District, Dallas County is in the Northern District. It doesn't make sense because Collin County is north of Dallas County, so you'd figure whatever is north of the Northern District would still be the Northern District, but no, it's actually the Eastern District. So the county lines, or where a particular county appears, isn't always quote-unquote logical. Okay, now let's talk about the courts of appeal, that middle layer. These courts of appeal are also called circuit courts. So that's a different name. It means the same thing. In the federal system, we have 13 circuits. By the way, in the Texas system, we have 14 Texas appellate courts. We don't call those circuit courts, but we do call them appellate courts. Again, it's appellate. Okay, so we have 13 in the federal system. There are 11 with numbers. So we have 1 through 11. Then there's one that's called the D.C. Circuit. And then there's the Federal Circuit. So that's how we get our 13. And they hear appeals from, of course, the district courts. Texas, Louisiana, Mississippi are what make up the 5th Circuit. Just as in the state system, in the federal system, the loser in the trial court gets an automatic right of appeal. If the litigant has filed the right paperwork by the deadline and paid the right fees, he or she has an automatic right to appeal to the circuit court that applies to his or her particular state. But after that decision, to appeal to the U.S. Supreme Court, you can always ask for review, but the vast majority of the time, the U.S. Supreme Court says, no, we're too busy. There's not a sufficient amount of time for the U.S. Supreme Court to hear every single case. So the vast majority of cases are final after the review by the circuit court, if even that's filed, because of course in most cases the trial court is the final decision. And later appeals again are discretionary with the U.S. Supreme Court. They can decide to hear it or not. And we'll talk about how that's decided when we talk about the Rule of 4. So the U.S. Supreme Court has 9 justices. That's the same as what we have in the Texas Supreme Court and the same as what we have in the Texas Court of Criminal Appeals. They can review decisions of the federal appellate courts, and they also review some state court decisions. So let's say the Texas Supreme Court issues a decision. I'm unhappy with it, and I think there's U.S. constitutional issues. Well, I could go directly to the U.S. Supreme Court if I wanted to. But the usual path is through the federal appellate court system. How does the U.S. Supreme Court decide whether to hear a case? Well, the legal mechanism for it is a writ of certiorari. You'll hear some people pronounce certiorari. You'll hear some people pronounce it certiorari. Both are correct. Certiorari is kind of more the old-fashioned term. It sounds really fancy, doesn't it? Sound very Latin-y to have all those vowels in there. But really, all this writ, and a writ is just a fancy word for a court order. All that a court order, a certiorari is it's a court order down to the appellate court, typically saying, send up your file. We want to review this case more. So if I am a litigant and I have lost in the 5th Circuit, so I'm going to the U.S. Supreme Court, I file a petition for a writ of certiorari. I'm asking the U.S. Supreme Court, please hear my case. And what I'm looking to do is I'm looking to persuade 4 of the 9 justices to hear my case. And this is where the Rule of 4 comes in. If I can persuade 4 of the 9 that this case merits review, then according to the Rule of 4, they will issue a writ of certiorari. Now, It might be that the 4 justices who decide that, yes, this case is meritorious, deserves review, under those circumstances, we might, each one of the 4 justices might have a different aspect that they find compelling. There might be one justice who thinks, yes, I absolutely think that this person who lost in the Fifth Circuit was cheated, and I'm looking forward to overturning that terrible Fifth Circuit decision. There might be another justice who looks at the case and goes, I think the Fifth Circuit did an amazing job, and I think this ought to be the law in all 50 states. So I want this opportunity to agree with the Fifth Circuit. You can see those 2 justices have a very different take on the case, but they might both vote under this rule of 4 to hear the case. And so it doesn't necessarily mean that the 4 justices are on the same side when they vote together. The U.S. Supreme Court typically hears cases usually in 2 scenarios. Or going back to, let's say I lost in Fifth Circuit and I'm filing a petition for a writ of certiorari, and I'm trying to decide, how do I persuade the U.S. Supreme Court to care about my case? Well, the first thing that's not going to work is telling the Supreme Court, oh, boy, my client's so nice and he really deserves a break. No. The U.S. Supreme Court can't worry about individuals. It has thousands and thousands of requests. It can't focus upon how this affects a single person. Instead, it focuses on the big picture. It's thinking, well, we're shaping the law by issuing these decisions, and so we have to think about, are we making the right decisions or not for the whole country? And so specific arguments that, oh, my plaintiff or my client really deserves to win are going to fall on deaf ears. The arguments that usually work are when you raise important issues of constitutional law. We say, hey, this is an important legal right, or the denial of an important legal right. And those types of issues, when they're developed, when the U.S. Supreme Court is being asked to develop new constitutional law, is an important basis for when the writ of certiorari issues. But there's another time, and that is when there's a conflict among the circuits. We said before that there are 13 circuits. Well, you can imagine that they don't always agree with each other. Different U.S. presidents have appointed many, just like for the trial court judges, the district court judges, the president appoints the circuit court judges with the consent of the Senate. But you might have had a very liberal president in one situation who's appointed several justices, and then the next term might be a very conservative president who's appointed other justices. And sometimes what happens is, kind of by the luck of the draw, you'll have certain circuits that are quite conservative and certain circuits that are quite liberal. The Fifth Circuit, the circuit that we're in, is considered a very conservative circuit. The Ninth Circuit, which is where California is, and it's a very big circuit, covers many states, that's considered quite liberal, just because of who was president when the most influential of those justices were appointed. So you can see, if you have conservative justices who dominate one court of appeal and liberal judges who dominate another, there's going to be areas they don't agree with, not because they're trying to advance their own personal ideas, but just because of their approach to the law is different. So it's not at all unusual for a conservative circuit like the Fifth Circuit to issue a decision that doesn't gel, that doesn't mesh with what the Ninth Circuit has done or is going to do, or vice versa. And when there's a conflict between the circuits, that's a type of case that the U.S. Supreme Court is very interested in addressing, because after all, we want to have, when we're talking about federal law issues, we want to have the same rule apply in all 50 states. And so when there's this conflict, when there's this dispute between the circuits, the U.S. Supreme Court kind of comes in as the tiebreaker and says, I agree with this circuit, not with this circuit. Or maybe both circuits are wrong and we're going to follow another path. So that's another big area where you'll have the U.S. Supreme Court accepting cert or issuing a writ of certiorari to hear those cases. Here is a schema about the federal system. One thing about it, though, that's a little bit misleading is that this is the overwhelmingly large number of courts. Yes, there are some courts here and some courts here, but this is the huge majority of the courts in the system. So this is not drawn to scale. This is much bigger than any of these categories. And then this is much bigger. I mean, there's 13 here. There's only one here, so you can see. So while this gives you an organizational chart, it kind of is a little bit misleading. This implies that this isn't as numerous as it really is. And here is a map of, here we go, this arrow's in the wrong place. Anyway, here is where we are, right here in Collin County. This is Collin County. It's just in the east. So you can see this is the Eastern District here where we are. And you can see Houston is about here, El Paso is here, Lubbock and Amarillo is over here, you know, Texarkana, and I guess Texarkana would be here, and Tyler would be over here. So it gives you a sense of the geography. So this breaks down, and you can see New Mexico has only one district. There's no lines in it. California has, looks like it has 4, but I think it only has 3. Maybe it does have 4 now. You can see that Nebraska only has 1. So usually it depends upon how populous the state is. 4 is the most that any state has right now. Could change, of course. Okay, so that concludes our discussion of our court system. Now we're going to talk about ADR, Alternative Dispute Resolution. We've been talking up to this point in the course as if all cases go to trial, but actually the vast majority of cases settle. The number that the textbook says is 95, but I think it might be more like 97%. But anyway, 95, 97, whichever one you want to go with. It's a very, very high percentage. The vast majority of cases never see a jury and certainly are never appealed. So it's important to know about how the system works when a case doesn't settle, but it's also important to recognize the majority of cases don't. So let's look at why do cases settle so frequently? And it really has to do with these disadvantages litigation has. Disadvantages are time. It takes a long time. Imagine that I'm a plaintiff. I was in a car accident and I was really disabled as a result of it. I don't have transportation. I lose my job because I've had to be off work. I have significant medical bills. I lose my health insurance because I'm no longer employed. I am in a real pickle. Maybe the other driver's insurance company offered me some money, but I want to sue. So guess what? I won't get any money until my day in court. But it might be several years before I see that money. And that's pretty difficult for me right now. How am I going to pay my mortgage this month? How am I going to buy groceries this month? How am I going to meet my financial obligations month to month to month to month until we get to trial? And so this time lag, it's not just inconvenient, but it can be devastating financially to someone. They can lose their home. They can not be able to feed their children. And so if you settle the case, and you get money now, even if it's less money than you could have gotten at trial, may be much more important. It may help you save yourself from losing your house, save yourself from having to file bankruptcy. So the delay factor in litigation is huge, huge, huge. Of course, litigation is also expensive. I'll give you an example. When I was in-house, one of the big facts that corporations face is that virtually any litigation is going to cost a corporation at least tens of thousands of dollars, and oftentimes, if it's going to go to trial, $100,000 or more, because attorneys are billing, right? That costs a lot of money. And so a corporation, when it's sued for something, and it doesn't have a quick and easy way to get the lawsuit dismissed, that corporation looks at the case and goes, okay, we're not going to be able to dismiss this before trial. If we go to trial, it's definitely going to cost us $100,000 to defend. So wouldn't it make sense to just, settle the case for something like $100,000 or maybe less? And that way, number one, we know how much we're going to have to pay. It's established, because of course you can pay the $100,000 and then lose and pay on top of that. But if you settle, say, for $80,000, the plaintiff is reasonably happy. You've saved at least $20,000, maybe more, and you've also saved the time of your employees who don't have to spend time preparing for the case. So it can save a lot of money, especially for the defendant who can't enter into a contingency fee arrangement because, of course, there's no possibility of the defendant making money. The last problem is inflexibility. Let me give you an example. Imagine that I have an extra neighbor who he doesn't, he has 2 dogs, and they're barking all the time. It's just driving me crazy. I happen to have a baby, and the dogs bark during the day, they bark at night, the baby keeps on getting woken up, and I can't sleep because the dog barking. It's a real nuisance. I've tried talking with him, but he loves his dogs. He says he can't do anything, and so I file a lawsuit against him. This same neighbor is also mad at me because he's trying to sell his house, and frankly, I'm not keeping up my yard that well. I got a baby, the yard's not my first priority. The shrubbery's looking a little rough. I don't mow the grass as often as I ought to. And he'd really like for me to maintain my yard a little more because people who come by to see his house see the jungle next door, and they don't want to move next door to that house. And so he has kind of a beef with me. Anyway, kind of a common sense approach that you might look to would be, okay, a neighbor with the dogs, you'll agree to keep the dogs inside so that the barking won't be as annoying, and the neighbor next door with the baby, agrees to mow my lawn once a week and to trim my bushes. And so we both end up being happy. I'm not nearly as disturbed by the barking dogs. He's able to sell his house, and of course, once he sells the house, the dogs go too, so win-win. That would be a very logical way to resolve that dispute. But guess what? The court system wouldn't have that as approach. Basically, the court system is about awarding money. And so if I win my lawsuit against the barking dog family, I might get money, but I mean, that's not really what I want. I want the barking to stop. And so so by settling it, we can come up with all kinds of creative solutions, like me agreeing to maintain my yard, or the person agreeing to keep his dogs inside. Or even things like you can have an alternative to resolution agreement that a party apologizes to the other party. So there's a lot more opportunities for solving problems creatively when you're looking at alternative dispute resolution. ADR, which is what alternative dispute resolution is commonly called, can take lots of different forms. We'll talk about a few of them, but really you can be as creative as you want and come up with your own brand of it. And if the other side agrees to it, then you're in business. Virtually all courts encourage alternative dispute resolution because, again, it's a way to dismiss cases. They have more cases than they know what to do with, so any way to get rid of the cases is a good situation for them. The most common type of ADR is negotiation. And this is when 2 parties just talk, sometimes between attorneys, I guess most commonly between attorneys once attorneys are involved, but you can even talk before a lawsuit is filed. I could just go over and knock on my neighbor's door and say, hey neighbor, your dog's been bothering me. I see you're trying to sell your house. You're probably annoyed by how terrible my yard looks. I apologize for it. Maybe we can work something out here. And you can negotiate. You can talk between yourselves and kind of do a back and forth. Well, I'll be willing to give you this. Well, I really want this. Well, that's not going to work for me. And come up with a creative solution in which both parties can feel like I gave a little, I got a little. The thing about negotiation is it's voluntary. The courts can't make parties, they can make the parties talk. They can make the parties go through the activity of negotiation, but they can't make them agree. Typically at the end of a negotiation, especially if attorneys are involved, you'll actually have a contract, a settlement agreement that the parties enter into and sign. Of course, if attorneys aren't involved, you might have a more informal arrangement. This is the most common way of resolving it. It's the same thing, by the way, that we do all the time in our personal lives. You know, when you want to get Mexican food and your friend who you're having dinner with wants to get a burger, maybe I'll decide to go to a place that has Mexican food and burgers. Or maybe you decide we'll go to have a burger this time and next time we'll have Mexican food. You negotiate with that person. If negotiation doesn't work, you can kind of increase the formality of the process by using mediation. In mediation, you have the 2 parties negotiating just as you would in negotiation, but you have another party who's called a mediator. This party is not, and when I say party, it's usually just a person. This person is not on the plaintiff side, is not on the defendant side. He is neutral. And as a result of his neutrality, he can he has, in some sense, more credibility with the parties. After all, when I go talk to my neighbor and I say, hey neighbor, you know, your dog's barking, it's really annoying me, he might say to me, well, there's nothing you can do about it. But I'm not necessarily going to believe him, because after all, he's got an incentive to lie. He's got an incentive to make it sound like there's nothing I can do about it, when really maybe I can do something about it. But when the third-party mediator is talking, and this person's usually an attorney, but they can be a paralegal, he or she typically knows a lot about the law in the area, and he or she isn't speaking with any agenda other than getting the case settled. So he's not on the side of the plaintiff or on the side of the defendant. Some nice things about it is it's an non-adversarial situation. It's problem solving, and it can really work to preserve relationships. If my next door neighbor and I are having a dispute, guess what? He's still going to be my next door neighbor the next month. He might be my next door neighbor for the next 20 years. It probably makes sense for us not to hate each other. That's not a very comfortable situation to live in. So maybe if we mediate the situation, we can figure out a way to at least have a reasonably civil relationship going forward. If negotiation and mediation don't work, you can always go to arbitration. This is the most formal process. It feels very much like a trial. You have that neutral third party, but instead of it being a mediator, it's an arbitrator. And so he isn't trying to settle the case, or she isn't trying to settle the case, but he or she is adjudicating it on the merits, saying you win or you lose. The book says that these decisions may or may not be legally binding, but the vast, vast majority are. Because, you know, it costs a fair amount of money to go through an arbitration. You have to have all the witnesses there. You really are just doing a mini trial. And so, well, if it's not binding, whomever loses is then going to say, well, I'm not bound by this. Maybe I'll win in the trial court. And so it's not necessarily the best way to resolve a dispute. So usually it's going to be binding. You may say, well, why would anyone want binding arbitration over litigation? Well, usually it can happen a lot faster. Usually arbitrations, because you're basically hiring a private judge who can make himself available or herself available whenever you want them to be, because you're paying them to do this. And so usually it can be resolved within 6 months. Because there aren't juries involved and there can be some simplified rules of procedure, they can be less expensive to have as well. So how do you end up in arbitration? Well, it really requires that both parties agree. If only one party wants arbitration, the trial court can't force the other party into it. Typically, and arbitration agreements are very common, typically arbitration agreements are part of the contract that started the relationship. So if I enter into a contract, for example, with my cell phone carrier, you know, I sign that big long piece of paper, probably in that document is an arbitration agreement if we have some kind of dispute. At the time that I signed the contract, there isn't any dispute at all, and I don't even probably read it that carefully. But let's say 3 or 4 years in the future, I'm still with that carrier, I have a dispute with them, and I file a lawsuit. Well, that carrier is going to say, oh no, Groover, look, you, in this contract that you signed 3 years ago, you agreed to arbitration. And so in that situation, the contract is going to require that I participate in arbitration. There are some times where a statute will require arbitration, but this is the most common way, for sure. Most common. And it's very, very common to have these. They can be in employment contracts, they can be in business-to-business contracts. The process will likely resemble a somewhat informal trial. It'll usually be in a conference room instead of a courtroom. There won't be a jury, of course. There's a submission agreement where the parties agree what the issues are that the arbitrator is supposed to decide. There will be a hearing where the arbitrator presides like a judge. There'll be opening statements, there'll be witnesses, there'll be evidence, and there will be closing statements. The arbitrator will render an award at the end. The award means decision. So you can see it starts with an A, award, arbitrator. And it's usually quite hard to appeal a binding arbitration decision. So once the arbitrator issues the decision, it's likely to be the final word. There isn't likely to be an appeal. Because after all, if you could appeal them, you're losing the benefit of arbitration, which is to have a quick final decision so the parties know how to proceed in the relationship. It's not impossible to appeal the decisions. In fact, I once did appeal an arbitration award and was successful in getting it overturned in the court system, but that's very unusual. Excuse me. Let's look at the other types of ADR that are mentioned. Binding mediation. This would be a situation where the mediator acts as, first of all, someone facilitating settlement, but if the settlement doesn't work, then the mediator gets to, at the end of the day, render a decision like an arbitrator. Then you can have mediation arbitration, where you start out in mediation and move to arbitration. There's early neutral case evaluation, where you have somebody basically tell you, this is how I would decide the case. I'm neutral. This is how I see the merits of the case. Then you can even have a mini trial where you actually you pay people to be jurors, and you evaluate, and so therefore you get a sense as to what a likely pool of jurors would view this case. Kind of lets you know. Of course, every jury is different, but it lets you know what might be happening. But these are not nearly as common as your negotiation, mediation, or arbitration. The first three are the most common. Let's talk about collaborative law. This is a hot topic out there in the law. 20 years ago, it didn't exist at all. It's most commonly used these days in divorce cases or child custody situations. In the collaborative law situation, the parties, and again we'll say they're the husband and wife who are planning for a divorce, agree to collaboratively or as a team resolve the issues. And the reason for this typically is that they need to develop a co-parenting approach, because after all, even after the divorce, they are still parents of their minor children. So they have to, or ideally they should have some level of teamwork. Even if their relationship as husband and wife is over, their relationship as parents is not over. And so collaborative law can be a mechanism for resolving the disputes that they have with as minimum tension as possible. Obviously, a divorce is always a painful process, but can be less painful than, say, having a trial. In the collaborative law situation, both parties have to agree to it. And what happens is that they meet with, they each have their attorneys, and they meet with a mediator, as well as sometimes some other folks might be involved, such as a psychologist or a social worker or an accountant or some other specialist in resolving the particular issues that they have. And they agree as they're going into this collaborative experience that if it doesn't work, that both parties are going to have to hire new attorneys and start over from the beginning. And so this motivates both parties to take the collaborative process very seriously, because it's going to be very expensive to restart this process. And in the collaboration, they're really focusing on problem solving. It's very much like mediation, but because both sides know that, well, we'll have to start from scratch, there's more willingness to share more information. And so, anyway, this is a popular topic these days in the legal business, certainly increasing, and paralegals can definitely be involved in that process. You can have court-referred ADR. In fact, judges routinely instruct the parties to engage in alternative dispute resolution. The court can force you to go, but they can't force you to settle. There are lots of different providers of alternative dispute resolution services. Governmental agencies, so for example, the EEOC has mediators that will help people settle for free. Courts oftentimes will have mediators who are on staff that will help. Then you can talk with private firms who would do it on a fee basis. The big arbitration group is AAA, American Arbitration Association. It has nothing to do with the Automotive Association. They are the most common way to get arbitrators if you're looking for arbitrators. There's also a text that talks about online dispute resolution. There can be a less expensive way of doing it, where people, perhaps if they're in remote locations, can Skype and resolve dispute resolution. I haven't been involved in those personally, but if it works, I think it could make some sense. Okay, so here we are at the summary. These are the topics we've already talked about. We talked about the issue of standing and justiciable controversy. We talked about personal jurisdiction, which answers the question of which state. We talked about subject matter jurisdiction, which talks about whether we're filing in state or federal court. We talked about a venue, which is different than jurisdiction, but it's a related concept. We talked about the rules of procedure, which is different than the substantive law. This tells you how you file lawsuits, when you file lawsuits, the details of the procedures in which you advance your rights, not specifically what the rights might be. We talked about our state court system, which has trial courts, which are, if they're courts of general jurisdiction, are called district courts. We talked about the intermediate courts of appeal, and we talked about the two highest courts in Texas, the Texas Supreme Court, the Texas Court of Criminal Appeals. We talked about the fact that in Texas, state court judges are elected, also Texas appellate judges are elected, and Texas Supreme Court justices and Texas Court of Criminal Appeal justices are also elected for 4-year terms. We also talked about the federal system, which is made up of district courts, which are the trial courts of general jurisdiction. We have our courts of appeal, and again, we're in the 5th Circuit. Collin is in the Eastern District. Dallas is in the Northern District. You need to know those two. And we have the U.S. Supreme Court, the final arbiter of federal and constitutional law. Unlike the state system, federal court judges and also appellate court justices and U.S. Supreme Court justices are appointed by the President. They're confirmed by the Senate, and once they go into position, they are going to have it for as long as they want it, unless they die or they are impeached. Then we talked about the various forms of alternative dispute resolution, the most important being negotiation, mediation, and arbitration. If you have any questions about this content, please bring them to class for our next class, and I'll be happy to answer those questions. Thank you for your attention, and have a wonderful day.